I think we'll get underway now. Welcome to the Assembly Insurance Committee hearing. We don't quite have a quorum, but I think we'll proceed with the first presentation. I see Mr. Chavez here, and I think Mr. Manshine signed in, but he's not here. So let's go with Mr. Chavez.
I need one more.
Do we? I need 7. All right, go ahead, sir.
Good morning, Mr. Chair and members. Today is an exciting day. It's actually probably a changing day. We have a labor bill presented by a Republican. A little humor? Okay, not okay. AB 1451. Currently, public safety officers receive certain special workers' compensation benefits that other employees do not receive, which includes up to 1 year of full salary in lieu of temporary disability payments. Last year, SB 527 block extended this benefit to lifeguard employed year-round on a regular basis, full-time basis by a county of the first class or by the city of San Diego. AB 1451 would include regular full-time city of Oceanside lifeguards, a city which I once had on it, proudly served in the council for 2 terms, to a benefit received by the same lifeguards who work only a few miles down the same beach. AB 1451 is supported by the Oceanside Peace Officers Association, the City of Oceanside, and the Oceanside Police Officers Association.
And for the record, we're acting as a subcommittee at this point because we don't quite have a quorum. Let me just see who else is here to speak in support of the bill or against it. Go ahead. We're hearing from people in support of the bill now.
James?
Yes, sir. Thank you, Chair Daly and committee members. My name is Jim Cunningham. I'm representing the Oceanside Peace Officers Association, which comprises of hundreds of our men and women in law enforcement, as well as our law enforcement personnel, and most importantly for this morning, the Oceanside lifeguards, the full-time lifeguards, sergeants, lieutenants, and captains. And as Assemblymember Chavez so eloquently stated, we're here because this bill is a very important bill to Oceanside POA and to the lifeguards. The very same beaches, sand, ocean, and most importantly for this purpose of this bill, peace officer rights, peace officer powers under 836.5 are conferred upon these Oceanside lifeguards. There are only 5 of them, but it's a very important bill for them. I'm not sure why they weren't included in the last bill. It's certainly important that they're included in this particular bill. And understanding the chair's staff's concerns about whether or not this is an important bill or necessary bill, it is. And I have a letter of support here, which hopefully the committee has received from the great mayor of Oceanside, Jim Wood, and the original is here for the record if necessary. I'm here to answer any questions you may have as to any of the concerns the staff may have regarding this particular bill, but we know of no opposition from any law enforcement agencies or any groups to this particular bill, and I'm here to answer any questions you may have.
Thank you. Why don't we take roll right now to establish a quorum?
Daly.
Here.
Beth Gaines. Travis Allen. Calderon. Cooley.
Here.
Cooper. DeBobne.
Here.
Frazier.
Here.
Gatto. Gonzalez.
Present.
Grove. Mays.
Here.
Rodriguez.
Here.
Cooper.
Here.
Excellent. We have a quorum. Is there anything else you'd like to add at this point, sir?
No, thank you.
All right. Are there other persons here to speak in favor of this bill? If not, are there persons here to speak against the bill? Any persons to speak against this bill? Members, we'll go to questions now. And I had one just to clarify. We do have the letter signed by the mayor of Oceanside. Is the city of Oceanside formally endorsing this request? Is this a request by the city?
Yes. So this is a letter of support from the mayor of the city of Oceanside. The city council themselves has no opposition to this bill.
But that's, and I should have directed the question at Mr. Chavez. But I guess the question is the city on record supporting this?
Right now, the city of Oceanside does not have a city manager. They're in a transition. And the governance is somewhat the short answer is no, because there's no city manager.
Okay.
But Mayor Jim Wood has been there for going on his third term, and he has signed a letter of support.
Okay. Thank you. As the gentleman from the Peace Officers Association stated, there are 5 lifeguards who employed by the city who are the subject of this request. Are there any member questions or comments? Ms. Gonzalez.
So first of all, thank you for bringing this forward. I'm completely supportive of this idea. We've worked on it in San Diego. Reading the chair's recommendation, if we need to get, and I talked to the author this morning, Oceanside's in a unique place now, but if we need to get letters of support from the majority of the sitting council members and mayor to make you feel more at ease, we talked about possibly bringing this back if you're still recommend no, because I think this is really important, and I actually, in knowing these council members and the mayor, think that a majority is supportive. We're just in a unique position right now in Oceanside. So my question's more to the chair, if your recommendation is still a no, would that be helpful?
Yeah, it's just a bit awkward, and thank you for your point. It's just a bit awkward because the city's not on record asking for this, and it's the city's money ultimately that will be spent. And I respect that the city may be in transition. That happens in cities, but it was simply a point that came up that the city's not on record, and even if they're in transition now, you'd think they would have been on record in the past on this point. But I'll defer to my colleagues if anyone else shares that concern. Is time of the essence on this matter? As Ms. Gonzalez said, we could allow time for the city to go on record.
How many days when would you be willing to entertain the hearing again? Forget the letters.
I'll let the consultant explain the calendar issue. Mark?
It's a non-fiscal bill, but the only exception to the Rule 61 problem is an urgency clause, and that's got its own complications at this point in time. In terms of rules and additional hearings in this committee.
If I could, then, what I'd like to ask you to do is actually go for the vote. Hopefully I'll be able to receive it, and I will work on getting all the letters from the council members to you before it goes forward. And I'm very confident with my contacts within the city of Oceanside, knowing them all, I can get them all on board.
Yeah, and again, I don't want to be splitting hairs too much, but normally when cities support something that they want the state government to do, there's a means they send a letter and says, on behalf of the city of Oceanside, we have voted, this is our position. To get individual letters from individual council members is different than that.
I could actually probably get it on the council and get it approved.
Yeah, I mean
that's what you'd want.
I think it's
okay.
It's a reasonable request.
Work with me to go forward. I'll do that.
If the city of Oceanside wants it, we'd like to hear from the city of Oceanside. That would be if they care about it.
I'm just asking for you to work with me on it.
Yeah, Mr. Frazier.
Mr. Chavez, why can't this process be done through collective bargaining in the city amongst the manager? And I know you don't have a city manager there now, but there has been over a period of time. Why can't that be negotiated through that process instead of the state mandating it to be done?
Jim?
Yeah, sure. I am general counsel for the OPOA. The MOU, or the collective bargaining agreement, is enabled under the Myers-Browne Act, as you know, the MMBE. And the reason why 4850 time has been amended 12 times and the enabling statute is probably 30 times is because an MOU does not have the stability and the oversight that a bill or amendment to this particular labor code has. For instance, there are many MOUs because of labor strife and such that become ineffective or inactive. There are MOUs with a change of bargaining units that are no longer in effect. So this particular benefit, and maybe I need to emphasize, it's an important benefit, and it arose because of an injury of a lifeguard in Oceanside on the
But
same
you're not
beach in
answering my
Sand.
question. Why isn't it going through collective bargaining?
Because for the same reason that this bill is specific to specific locations, because the MOU, or the collective bargaining agreement, does not withstand the test of time as legislation does. And it's important that if Oceanside in the future lifeguards are going to be taken out of this bill, you'll have committees like this, you'll have oversight, you'll have input from the community and for the citizens, as opposed to simply whoever happens to be at the bargaining unit. So this is an important bill, an important benefit, if you will, for the lifeguards, and as such, that's why they're seeking an amendment to this bill.
But most of these MOUs do withstand the test of time. I've negotiated MOUs on both sides, so I mean, once in a while, but I would say the majority of things that are negotiated at the table by the bargaining units, remain in effect.
The idiosyncrasies of an MOU as it applies to 4850 time are specific. There's only one in the state of California that provides for 4850 time-like benefits up in Los Angeles City, because there are tax ramifications that are important. 4850 time is a tax-free benefit provided to the members. You may try to, in an MOU, legislate around the IRS or legislate around the state rules as it applies to taxes, but that's not the proper way to go. The ramifications of 4850 time run deep within the tax structure of the state of California. And as you know, Assemblymember Cooper, we cannot draft MOUs that circumvent important factors of the state. That's why you keep seeing amendments to 4850 time as it applies to adding 12 different types of folks that comply with it, as opposed to the MOUs.
Are there other questions or comments by committee members? Mr. Chavez has said that he'd like to see a vote out of this committee, and then he'll obtain a formal letter of support from the city.
And if I do not receive that formal letter of support, I'll pull the bill on my own.
All right. All right. I'm going to recommend that we support this request, and give one more chance for questions or comments. If not, we'll call the roll. We need a second.
Second.
There's a motion and second. Roll call vote, please.
Daly.
Aye.
Daly, aye. Beth Gaines. Travis Allen. Calderon. Cooley.
Aye.
Cooley, aye. Cooper.
Aye.
Cooper, aye. DeBobney.
Aye.
DeBobney, aye. Frazier.
Not voting.
Gatto. Gonzalez. Aye. Gonzalez, aye. Grove. Mays.
Aye.
Mays, aye. Rodriguez.
Not voting.
The bill's not out yet. It'll be on call. There are 6 votes. What's the count? 6? 6 yes votes, and it's on call.
Thank you very much.
Is Mr. Mindshine here yet? He was the first in the sign-in order. Let's do the consent calendar, folks. We have 4 items on consent.
Second.
Motion and second on the consent calendar. Roll call vote, please.
Daly.
Aye.
Daly, aye. Beth Gaines. Travis Allen. Calderon. Cooley.
Aye.
Cooley, aye. Cooper.
Aye.
Cooper, aye. DeBobney.
Aye.
DeBobney, aye. Frazier.
Aye.
Frazier, aye. Gatto. Gonzalez. Aye. Sorry. Gonzalez, aye. Grove. Grove, aye. Mays.
Aye.
Mays, aye. Rodriguez.
8 votes.
All right, the consent calendar is approved. Freddie?
I'm sorry, I didn't hear.
I wasn't sure.
Rodriguez, aye.
Yes.
Good catch. Good catch, Mr. Rodriguez. I think Mr. Gibson is next up. If I'm welcome, sir.
Good morning.
I see Holden. He must have signed in. Okay. Go ahead, sir.
Move the bill. Second.
Brief summary, please.
Sure. Thank you very much. Committee members, Mr. Chair, AB 511 will ensure all full-time public safety employees are provided with fair, equal health care benefits. Under current law, the legislature provides public safety employees health care coverage for injuries and health conditions that links their job and their work to their working performance. Our laws also provides that each employee may be challenged around these claims. Unfortunately, these laws were drafted in the 1970s, and such they do not include many categories of peace officers that did not exist back then. Despite performing these same duties with their colleagues, these men and women risk their lives daily for our safety and are not being provided with the critical health care benefits they deserve. I ask for an aye vote. We have individuals here representing the law enforcement community who will provide testimony.
This is a time for those in support to express it. Go ahead.
Thank you, Mr. Chair, members. Ryan Sherman on behalf of the Los Angeles County Professional Peace Officers Association. We're the sponsors of the bill. We're looking forward to working with the committee and others as we narrow this bill as it moves forward. We're hoping that we'll be able to get our members, the peace officer members that are currently not covered, provided for with the workers' compensation scheme. Also, we're looking forward to being able to cover some of the custody assistants and some of the security officers that are currently in penal code but are not peace officers. And so we look forward to your vote, and we would ask for your aye vote. Thank you.
Thank you, Mr. Sherman.
Mr. Chair and members, Matthew Seiberling on behalf of the Riverside Sheriff's Association, here specifically on behalf of the coroners and deputy coroners represented by the association. These folks deserve equal protection. They experience the same risks, illnesses, injuries that their fellow peace officers do as well, and respectfully ask for your aye vote. Thank you.
Thank you.
Mr. Chairman, members, Randy Perry with Aaron Reed and Associates on behalf of PORAC. We sponsored a narrower bill last year. As the committee analysis pointed out, the governor vetoed the bill, asked for empirical evidence. We have gone back and are currently gathering that empirical evidence, so we're hoping that when if the bill reaches the governor's desk, that he will look at it favorably this year.
Thank you, Mr. Perry. Any other comments in support of the bill? Any comments in support of the bill? If not, we'll go to those who are opposed to the bill. Step up to the mic, please. You do it from the table or from the mic up there, either way. Go ahead, please.
Good morning, Mr. Chair and members. Faith Conley with the California State Association of Counties. We're in opposition to this bill, just like we were in opposition to AB 2052 from last year. This bill actually goes even farther than that to include part-time officers as well as those who are not even defined in Penal Code 830. It represents a massive expansion of presumptions to those officers that aren't necessarily confronted with the major hazards that are confronted by those public safety officers that are in receipt of these presumptions today. As the proponent said, there's no evidence right now that would suggest that they do experience those hazards that would warrant these presumptions being expanded to them. I will say that public safety presumptions right now for most of our counties provide the actual highest workers' comp claim costs for us. An expansion of that to those employees that aren't even defined in this bill, such as security assistant and those that aren't defined in 830, it's going to create huge liability costs for us. LA priced 2052 out at about $1 million annually. That can only obviously go up with the passage of this bill that's even broader. So with that in mind, we would strongly oppose this bill.
Thank you. Go ahead.
Thank you, Mr. Chair and members. Jason Schmelzer here on behalf of the California Coalition on Workers' Compensation and CSAC Excess Insurance Authority. First, just want to thank the member, obviously, and his staff. We've done a lot of these bills in the past, and they've been very open about the process and the procedure as the bills morphed and moved, so want to acknowledge that. We are, of course, opposed to the bill. We've been opposed to previous bills of this nature. AB 2052 was referenced from last year. And frankly, we agree with the governor that presumptions should be used rarely and only when justified by clear and convincing scientific evidence. And frankly, that's just lacking here. Secondarily, on presumption policy in general, we do have a concern with just the general application of presumptions and whether or not they are even needed in the workers' compensation system. We have a no-fault system in California, which means if it arose from the job, regardless of fault, it's covered by the workers' compensation system. Secondarily, we have what's known as the liberal construction clause in the state of California, which means judges are required by statute to liberally construe the law to the benefit of the injured worker. Frankly, we think the standard of evidence that's required to accept a claim is relatively low, so a presumption is unnecessary. So what we could support on presumptions is frankly a broad examination of the performance of presumptions, the need for presumptions, the current application of presumptions, and the cost. But unfortunately, we cannot support the bill that's in front of you today, and we'd respectfully ask for your no vote.
Thank you, Mr. Schmelzer. Others in opposition, please go ahead.
Amber King with the Alpha Fund for the reasons previously stated, also in opposition.
Thank you.
Mr. Chair, members, Phil Vermeulen representing Acclimation Insurance Management Services and Allied Managed Care. We too have a serious concern about the bill and the added costs. Believe the existing system works well and are vehemently opposed. Thank you.
Thank you, Mr. Chairman, members. Julianne Broyles here on behalf of the California Association of Joint Powers Authorities. We are the public risk pools that cover many cities and counties and special districts throughout the state with their workers' compensation risks. We look at any expansion of presumptions as something that our members, who are cities and counties and school districts and library districts, all having to go back to their respective employers and say, your general fund is going to have to fund these new presumptions. So when this bill comes to out of this committee and likely goes to the Appropriations Committee, we hope a serious consideration is given to the cost and the impact, because we will have to pull dollars from other programs that our local constituents want in order to pay for these presumptions.
Thank you.
Mr. Chair, members, Steve Kelmer on behalf of the Board of Supervisors of Los Angeles County. We apologize, but we have a late opposition to this bill for the reasons previously stated. Thank you.
All right. Committee members, questions or comments? Mr. DeBobna.
Mr. Gibson, thank you for bringing this bill up. I am someone that believes the workers' compensation system does need reforms. I do believe that there's a lot of issues within it that need to be changed, but I also believe that there's a special obligation we have to those that protect our cities, protect our families, and risk their life every day to make sure that we're safer. I will be supporting this bill today because of that. My one ask is that if, as the bill goes forward, that we can tighten the non-peace officer's definition. I want to make sure that people that are facing the same challenges, facing the same risks, and have the same potential to be injured on the job as those that have a badge are also protected. But I would agree with one of the previous speakers in opposition that this is a very high threshold to have presumption. And I want to have it reserved for those that truly, I think, are worthy of it. Last year I voted for a bill that would allow nurses in our hospitals to have it. I think that was a worthy step. But I see the line, and I think that this line should remain intact and hopefully honor the fact that it should be those that are in law enforcement and those who have jobs that very specifically resemble the responsibilities, challenges, and risks of law enforcement. Because what we don't want to see is a slippery slope where we add more and more categories to this, and that erodes, in the end of the day, the protections that we provided for our law enforcement officials who do risk their lives every day. And I know you are one of those members, and I thank you for your service to our community. So I will be supporting the bill today, but I would just ask as we move forward, we keep working on that definition. Thank you.
Thank you very much.
Ms. Grove is next, then Mr. Cooper, and Ms. Gonzalez, did you want to comment? So Ms. Grove is next.
Thank you, Mr. Chair. I have a question and then a comment. Is there any evidence to show that, and by the way, I appreciate all that law enforcement does to keep us safe and all the work that you guys do. I want to know if there's any evidence to show that law enforcement has been denied workers' compensation benefits based on a claim for benefits, without, clear and concise evidence that it's fraud or whatever, but have they been denied benefits?
Right.
If I may. Yes, the answer is yes. We have a number of custody assistants which act as jailers in the LA County jail system, and many have come forward with different injuries, diseases that they've acquired at work, and instead of having the presumption, they've had to go to great lengths to try to establish proof that it was acquired at work and not elsewhere. Switching the presumption to the benefit of the employee will greatly reduce that time difference where they're going without the coverage and the care that they need.
You have evidence of that? And the reason why is because I do believe that the workers' comp system is construed in a no-fault system where you don't have to prove fault by, it's a no-fault system. And it is, like the witness said, it's liberally construed to benefit the employee on all counts of the law. So do you have evidence or proof of that? And the reason why I'm concerned is because I have a huge issue with the presumption, meaning that a hernia, they could have been, chopping wood, working under their car, lifting anything, but it's automatically from this point forward, if this bill gets passed and the governor signs it, is that it's presumed automatically that no matter what their outside activities are, that it's presumed it actually happened on the job. And that bothers me just a little bit. If it didn't happen on the job, then this county or the individuals responsible for that workers' comp shouldn't be on the hook for that. It should be their health care or whatever it is, which is in this case the county as well. But the benefits are construed differently for payment of wages on temporary disability or permanent disability. So I understand the cost factor of it. So I guess my question or my concern is that with the presumption, it ought and your statement that you made, you said, and I think that it was a misstatement, you're leading the dais to believe that they're not covered. Are any of these employees not covered under the workers' comp system or workers' compensation insurance?
They are covered under workers' compensation. However, they do not currently have the workers' comp presumptions.
Correct.
That the benefit or the illness or the injury occurred on the job.
Okay, because in your statement you said that these people were not covered.
I'm sorry, then I did misspeak. Yeah. I did mean to say that they're not covered under the presumptions. And the presumptions, you remember, are rebuttable. If there was something that was clear outside of work where some type of injury or illness happened, they are rebuttable. The county can come forward, the city can come forward and say, hey, look, this didn't happen on the job. And if they can prove that, then that wouldn't qualify then.
And the claim itself is rebuttable. I mean, the claim itself, the way the system is now, if the county says that it's not a work-related injury, the employee has the rebuttal to say it is and to get it covered under the benefits. It's just not a presumption.
Right.
So they are covered under workers' comp.
Of course.
Okay. I just want to make that clear. Okay. I have a huge problem with presumptions in any industry because I don't think anybody should presume that it's someone else's fault when it's not. I mean, especially when the law is liberally construed to benefit the employee, which is good because it's a no-fault system, which is good. And I think that's a good program. But to throw presumptions in there, I tend to align myself with the governor, which is very often strange on my part. But I do align myself with the governor, and I appreciate his knowledge on the workers' comp system, where he believes it should be clear and concise scientific evidence on presumptions. So I can't support the bill, but I do appreciate all you do. And if you have evidence to the contrary that law enforcement officers are having a problem with their workers' comp cases, I'd like to see it. Thank you.
Mr. Cooper's next. Mr. DeBobna, did you have a follow-up on that? Sorry, Mr. Cooper.
I'll defer to you.
Yeah.
But I think, could you just clarify quickly on the presumption? This doesn't affect every category of possible injury. These are specific injuries that are most likely to occur within the definition of the job set out. So, if someone got a specific injury at home, you couldn't just automatically say, well, I have presumption, so I'm going to use that under the workers' comp system. Can you just quickly go into some of the injuries that might be considered within the presumption for these type of jobs?
Sure. Hernia, TB, meningitis, a number of the diseases and injuries that are consistent with the duties that are traditionally and regularly performed by the officers. That's really what we're going at. We're not trying to get a workers' comp presumption for a broken arm that happens at home riding a skateboard, nothing like that. Yeah. We're looking at just trying to protect the injuries and the diseases that are job-related that regularly happen.
So you would say that this is a narrow category of injuries that you could say you have scientific evidence to back up that these injuries likely do occur for these individuals carrying out these duties that are most likely to happen on the job.
Yes, and that's how they developed over the years. Yeah. It was very specific, different injuries and diseases, and as the gentleman from PORAC mentioned earlier, they're putting together some information. We're collecting them, the same information from our members as well, to make sure that by sometime this summer, we'll have that empirical evidence to show to the governor and to the legislature the exact need and the problems that our members are facing without these presumptions.
Mr. Cooper, thank you for your gracious patience with the other member.
First of all, I want to thank Mr. Gibson for bringing this forward. I do agree with Mr. Bobney. We need to tighten it down on who's covered in this. And I think what some of the opponents are forgetting, especially from the cities and counties, they negotiated a long time ago. They didn't want a deputy sheriff or a police officer sitting in these correctional facilities guarding inmates. They wanted a lower classification of person that made less money. Right. So that was negotiated a long time ago. But the bottom line, those folks are doing the same work still. Mm-hmm. So if you're in a jail, whether you're a deputy sheriff, and here in Sacramento County, deputy sheriffs, or in L.A. correctional officers, you're doing the same job, dealing with the same folks. So in my mind, you should be entitled to the same workers' compensation. And really, it's exemptions. And really, it's a presumption, and it's a narrow field. So hernia, you're lifting up people, picking them up, arresting them, fighting them, heart attacks, certain things like that. So you can't have it both ways. You want a lower class, lower pay, but at the same time, you've got to afford them the same benefits. So, I mean, I think in some aspects, they're being disingenuous. This was negotiated a long time ago to save those entities money, and they saved a great deal of money by having a lower classification of employee. So I don't have a problem with this. They're doing the same work. Let them have the same protections. So I'm supportive of your bill.
Thank you.
Ms. Gonzalez, you're up.
Obviously, I'm supportive of the bill. I carried a very similar measure last year. Thank you for carrying it, Mr. Gibson. I'd just like to be added as a co-author.
Thank you.
So will I. As I.
Thank you.
It's now a love fest. Started by DeBobney. Other questions? Any other questions or comments? Mr. Rodriguez, did you?
Just want to make sure I'll add me as a co-author. One, I want to thank the author for bringing this bill forward to protect our officers out there that are doing this job 24/7, 365 days a week. Thank you very much.
Thank you.
Mr. Mays.
There are some things listed here. One of the things that are listed is heart trouble. For me and my family, I've got family history of heart trouble. Is when we're talking about presumption, is family history taken into consideration or other outside behavior when dealing with things like heart trouble?
No, it is not. This would be a presumption for any heart trouble that arises. Now, if there is something outside, if there is family history, if there's something that the city or county is alleging is not connected to the injury or the disease, then it can be rebutted.
Anything else, Mr. Mays?
Yeah. Oh. How would that work in practice? How would the city or county, in that regard, how would they go back to look at family history for those sorts of illnesses? How would they make that case?
I'd have to leave it up to them. The presumption is that it occurred on the job, and if the city had proof that there was something that occurred outside of work, it would be their responsibility. Currently, it's the responsibility of the employee to prove to the city or county the presumption or the illness occurred on the job. This would switch that and require the city or county to then be able to rebut that.
Yeah. Mr. Chair, I think I can help on that. And also, you think about a situation, you're in a jail or facility, and you're getting in fights on a daily basis, so your heart rate's elevated, and so is your blood pressure. So the wear and tear on your heart is more frequent than the average person, even with a family of heart disease. So every day at work, something's going on where your heart's pumping faster, that blood's pumping faster. So it's actually wearing your heart. That's why it's presumptive with that, because we have a lot of heart attacks in law enforcement because it's a high-stress job.
Other questions or comments? Do we have a motion and second already? We already do. Mr. Gibson, would you like to close?
Yes, thank you very much. I appreciate the committee's consideration as well. I vote just to speak to and address some of the issues that was raised. I think that Member Cooper summed it up. I'm a former police officer. I'm in the city of Maywood when Maywood had a police department that was taken over by the LA County Sheriffs. And so when individual go into public safety, there's a physical agility, there's a psychological, there's a number of different background and applications you must fill out, including and not limiting whether or not there's any family history of heart issues and things of that nature. And so as Mr. Cooper has already indicated, that it's a high-stress job, and certainly this could be certainly brought on by the high stress in terms of working jails. And, you know, being a public safety officer is a high-stress kind of position just to be in. And, again, this is focused enough, very specific in terms of we're talking about work-related issues and issues that will come up in terms of by performing your job and those injuries taking in consideration, whether it's a broken arm in a fight, certainly you can indicate that that issue took place at your job, whether it's a smoke inhalation, and you're a firefighter. We have that for firefighters right now, where if a firefighter comes down with lung cancer, you can automatically presume that because that person in the job they're doing has been brought on based on the work that he or she is doing as relates to fighting fires. And so this, I believe, set forth a very broad, but also it captures the focus of public safety officers, those individuals that protect us, those individuals who are in our jails providing the protection that we need. And I think this is focused enough, and certainly I ask for an aye vote and appreciate the committee's consideration.
Thank you, Mr. Gibson. We'll have a roll call vote now.
Daly?
Aye.
Daly, aye. Beth Gaines? No. Beth Gaines, no. Travis Allen? No. Travis Allen, no. Calderon? Aye. Calderon, aye. Cooley? Aye. Cooley, aye. Cooper? Aye. Cooper, aye. DeBobney? Aye. DeBobney, aye. Frazier? Aye. Frazier, aye. Gatto? Aye. Gatto, aye. Gonzalez? Aye. Gonzalez, aye. Grove? No. Grove, no. Mays? No. Mays, no. Rodriguez? Aye. Rodriguez, aye. 9-4.
That bill passes with 9 affirmative votes.
Thank you very much, committee.
Thank you, Mr. Gibson. Ms. Grove.
I would like to request a point of personal privilege to introduce my foster youth today, Leslie Marin, sitting in the first row right there from Kern County. You wave.
Welcome, Leslie. Welcome. Thank you for attending.